Tab 36 is C268. You have the reaction of Mondo Minerals to the tender that warranted a letter from Mondo's attorney addressed to the head office of the district mining. It's dated May 18th, 2005. First question is, when did you see this document for the first time?
Predpokladám, že keď je to...
I suppose when it's from May 2005, since I'm CC'd to the main mining office, I suppose that I have seen this document.
Can I walk you to 1, 2, 3, 4, 5, 6 paragraph, sixth paragraph after item 7, new close, Slovakia SRO. And it's item 1. It says the company agency SR consists of one person. It was established on April 31st, 2004 by a natural person, Ms. Korejova. The execution of a mining activity and of activity executed with mining methods was inscribed in the object of activity of the company that handles also with the brokering, trade activity and accountancy only on March 31st, 2005. Is that true first? Did you verify whether the company's purpose was brokering, trade activity and accountancy? Is that true? Did you verify that? Brokerage is not good, huh?
Najprv by som...
I first would like to see the paragraph because your colleague is not keeping up to show it to me. Let me just read it first.
And then I continue while you're reading. It says, given that this is a company that does not have sufficient capital and financial means necessary for the mining of the deposit, it was selected by the committee as first, despite the fact that it did not demonstrate financial means necessary for the mining of the deposit. That is estimated at approximately 500 million koron. Document with the company submitted in connection to this into the selection procedure labeled as indicative credit commitment from the branch office of the Tatra Bank is not in any case a document confirming financial security, since this is a non-binding loan promise by which the bank itself bound only to negotiations with this company about possible future provision of a loan and its conditions, while the bank in the document emphasized that any obligations do not arise from this indicative credit commitment towards this company. Have you read it now?
Áno.
Yes.
And I have, is that, did you verify whether this gentleman is telling the truth that the company that won, Economic Agency, is a company engaged in the brokering, trade activity, and accountancy only? Did you verify, is that true?
Táto sťažnosť je adresovaná.
This is addressed to the district mining office. We've only verified the consequent objection. So I'm not sure whether this initial objection was because we did not have jurisdiction in the first instance. But with the...
Verify or not, forget about this letter now. Did you verify or not that the winning company was engaged or not only in trade activity or brokerage and accountancy only on March 31st, 2005? Did you verify that information? Is it true?
Within the appellate proceedings, I'm sure we have verified this fact, but not from the viewpoint of assessing potential change of order about which only the Selection Commission could decide, because neither district nor main mine office have authority by law to enter in changing the order of bids.
Is it true that that company at the time was engaged in brokering, trade activity, and accountancy? Is it true?
And the excerpt from the business register is part of the file. It is possible, but since they were bidding in a tender, they had to be holders of mining activities.
But they had brokering, it was a
No.
brokering firm when it applied, correct? Brokering, trade activity, and accountancy. And if that's the case, then how does that on its face is compatible with the 2002 amendment, where you're trying to get out of the intermediary systems, those that are in the middleman? How is that compatible? It's not, is it?
Kde novela z 2002 hovorí,
Where does the 2002 amendment say that we're trying to get rid of some intermediaries?
voľný výklad
Your free interpretation of the act strikes me as odd, because the 2002 amendment says that in order to avoid blocking of Slovakia's owned deposits, which was 25 to 30% occurrence before that amendment. In 2005 to 6, this blocking dropped down to 4 to 5% due to other reasons other than inactivity of companies, because all who were not excavating were tendered for these particular mining areas. Not a single case was the case that selection committee selecting the winner would abolish or change, or court would abolish or change decision of selection committee.
I understood paragraph 8 at the end yourself saying that those who are trying to block the deposits, or some that could have waited for better market conditions to commence activities, or to transfer the areas to other interested party, others were unable to finance the actual mining activities. But anyways, I'll move on to the next issue in that document, which is document with the company submitted. Here there's an allegation of one of the 5 losing bidders saying that the winner didn't submit anything other than a document that is worth 0, that is not a commitment, but only a commitment to negotiate. And I would assume that when you have a company like this that wins, following the revocation of somebody's rights, upon receipt of a very reputable company's letter saying these guys are phony, they have no means to verify whether that is true or not, in the interest of the legitimacy of the process, but also in the interest of the public, to ensure that that company didn't just provide the document that Mondo is describing. So the question again is, did you verify whether Mondo Minerals' allegation is correct or not? No, you didn't.
máte za
Do you have in mind that the reputable company whose Representative Keller discussed with Minister Rusko, this Mondo Minerals or Mondo Minerals Slovakia?